Most people assume a hidden camera planted by family isn't a criminal matter, it's just a betrayal to handle quietly. That assumption is exactly what makes it easier to get away with. This is the story of Priya, a 28-year-old in a Delhi joint family, who discovered a camera disguised as a smoke detector above her bedroom wardrobe. What she did next changed everything. The camera was small, professional grade, and had been running for at least 3 weeks. Priya found it while cleaning after her mother-in-law left for the market. Her hands were shaking. She didn't confront anyone. She didn't delete the footage. Instead, she took photos of the device in situ with her phone, noted the exact time, and called a friend who worked in IT security. Here's what most people get wrong: they assume the legal burden falls on them to prove intent. It doesn't. Under Section 417 of the Bharatiya Nyaya Sanhita, the new criminal code that replaced the IPC in 2023, voyeurism is defined as intentionally recording or observing a person without consent in a context where they have a reasonable expectation of privacy. A bedroom qualifies. The burden of proving intent shifts to the person accused once the act is established. Priya's IT friend confirmed the device was actively transmitting to a cloud account registered under a throwaway email that became her evidence. Within 24 hours, she walked into her local Delhi police station, not with anger, but with a folder, the photographs, the technical report, a timeline, and a written statement describing the installation and duration. The constable at the desk took her seriously because her evidence was concrete. The FIR, First Information Report, was registered under Section 417 of the BNS, plus Section 376 for violation of a person's privacy and dignity. The officer also noted potential charges under the Information Technology Act for unauthorized recording. Priya understood something critical: a police complaint isn't just about anger. It creates a legal record, triggers an investigation, and protects her from being silenced or gaslit by family later. Her mother-in-law claimed it was a misunderstanding, a gift from an online seller that she didn't fully understand. That defense fails under law because installation and placement with intent to record a private space constitutes the offense, regardless of claimed innocence. Honestly, this is where family members often derail the process. They pressure the victim to withdraw the complaint for family peace. Priya was warned of this. She refused. The investigation took 6 weeks. Police seized the device, recovered the cloud footage, and traced the email account to the mother-in-law's phone. The charge sheet was filed. But here's the real outcome most people miss: the case didn't go to trial. Instead, the family court intervened through a counseling and reconciliation process under the Hindu Marriage Act. The mother-in-law was cautioned, a protection order was issued, and Priya secured documented evidence of the violation for any future proceedings. 3 lessons from this story. First, evidence matters more than emotion. Document, photograph, and preserve. Second, filing an FIR isn't about revenge, it's about creating a legal record that protects you. Third, understand that Section 417 of the Bharatiya Nyaya Sanhita explicitly criminalizes voyeurism and privacy violation in intimate spaces. Your bedroom is your sanctuary under law, not a surveillance space for family. If you are facing privacy violation, unauthorized recording, or surveillance in your home, don't stay silent. Call the Women's Helpline at 181 or file a police complaint at your nearest Indian police station. The legal framework exists. Use it. Subscribe for more breakdowns of Indian family law, court processes, and the real protections you have under the Bharatiya Nyaya Sanhita.